Hello everyone. Today we will learn some basic concepts about jurisprudence through some basic MCQs. So without wasting any time, let's start with it. Let's start with the first question. The first question is, who said that custom is per se law? The options are A. Savini, B. Hart, C. Coke, or D. Puchta. The correct answer to this question is option A, that is Savini or von Savini was the one that said that custom is per se law. Coming to the next question, who wrote the essay Von Beruf in 1814? The options are A. Puchta, B. Hegel, C. Thibaut, or D. Savini. The correct answer to this question is option D, that is Von Savini was a jurist who wrote the essay Von Beruf in 1814. The next question is, the self-interested causes a conflict between individual will and a general will. Who expressed this opinion? The options are A. Maine, B. Von Savini, C. John Austin, or D. Puchta. The correct answer to this question is option D, that is Puchta was the one who said that self-interest causes a conflict between individual will and a general will. The next question is, who wrote the book Das Recht des Bestes? The options are A. Von Savini, B. Puchta, C. Henry Maine, or D. Hegel. The correct answer to this question is option A, that is Von Savini was a jurist who wrote the book Das Recht des Bestes. Moving on to the next question. Pound defines law as which of the following? The options are A. Positive morality, B. He says it is a psychologized command, C. Law is a social fact, or D. It is a social institution to satisfy social wants. The correct answer to this question is option D. That is, as per Pound, law was a social institution to satisfy social wants of the people. The next question is, who stated that one has any other right than always to do his duty? The options are A. Holland, B. Austin, C. Dugwit, or D. Salmond. The correct answer to this question is option C, that is, Dugwit was the jurist who stated that no one has any other right than always to do his duty. Now let's move on to the next question, which is, who said that in possession there is manifestation of individual will? The options are A. Von Savini, B. Kant, C. Hegel, or D. Rousseau. The correct answer to this question is option C, that is, Hegel was a jurist who said that in possession there is manifestation of individual will. Now let's move on to the next question, which is, two main theories of legal rights are what? The options are the will theory and the realist theory, B. The will theory and the interest theory, C. The will theory and the concession theory, or D. The interest theory and the symbolist theory. The correct answer to this question is Option B, that is, the main theories of legal rights are the will theory and the interest theory. So now let's talk about what is will theory and the interest theory. Let's now understand the two basic theories, that is will theory and interest theory. Will theory states that the right is an inherent attribute of human will. It says that the purpose of law is to allow the free expression of human will. As per this theory, it advocated by the scholars like Hegel, Kant, and Hume, and so on. The subject matter is derived from human will. While on the other hand, interest theory contradicts will theory. It was given by von Ehring. He stated that he stated that the right is a legally protected interest. He also asserted that the basis of legal right is interest and not will. As per his theory, the main object of law is the protection of human interest, and will has nothing to do with the law. Now, after this, let's move on to the next question. That is, who amongst the following defined jurisprudence as the scientific synthesis of the essential principles of law? The options are A. Salmond, B. Austin, C. Allen, or D. Bentham. The correct answer to this question is option C. That is, Allen was a jurist who defined jurisprudence as the scientific synthesis of the essential principles of law. Now, moving on to the next question, who divided jurisprudence into general and particular jurisprudence? The options are A. John Austin, D. Pushta, C. Locke, or D. Holland. The correct answer to this question is option A. That is, John Austin was the jurist who divided jurisprudence into general and particular jurisprudence. For him, general jurisprudence was a morality and a particular jurisprudence was had the sanction of the sovereign to its subject. Now let's moving on to the next question, which is who supported the absolute power of sovereign on utilitarian grounds? The options are A. Jeremy Bentham, B. A.V. Dicey, C. Hobbes, or D. Austin. The correct answer to this question is option A. That is, Jeremy Bentham was a jurist who supported that the absolute power of sovereign on utilitarian grounds. The next question is related to the Constitution and on a very landmark judgment. So let's see and understand this case as well as this law of the Constitution. The question states that the interpretation given to the Article 21 by the Supreme Court in Menka Gandhi versus Union of India AIR 1978 SC 597 can be best classified as which of the following? The options are A. Naturalist theory, B. Positivist theory, C. Sociological theory, or D. Historical theory. The correct answer to this question is option E. That is, the interpretation given to the Article 21 by the Supreme Court in Menka Gandhi case can be classified as a naturalist theory of law. Now let's talk about a landmark case which is Menka Gandhi versus Union of India. The parts of this case was that the petitioner, that is Menka Gandhi, was ordered by the Regional Passport Office, Delhi, to surrender her newly made passport within 7 days due to central government's decision to impound it in public interest in accordance with the Passport Act of 1967. When the petitioner asked for a valid reason for impounding her newly made passport, no reason was given by the public authorities, and it was only stated that the impounding is being done in the public interest. When the petitioner filed a case in the Supreme Court, the court, after analyzing the facts and hearing both the sides, held that the right to travel and go outside the country must be included in a right to personal liberty. The scope of personal liberty in this case was increased, and it was held that the personal liberty was held to include all the rights granted under Article 21, which also includes right to life and personal liberty, as well as other rights related to the personal liberty of a person. Now, moving on to the next question. Auguste Comte's view that society is like an organism and it can progress when it is guided by scientific principle is also known as which of the following? The options are A. Scientific approach, B. Scientific positivities, C. Law of metaphor, or D. Scientific outlook. The correct answer to this question is option B, that is, the view that society is like an organism and it can progress when it is guided by scientific principle is also known as scientific positivities. The next question is, who says the only right which man can possess is always to do his duty? The options are A. Comte, B. Duguid, C. Salmond, or D. Austin. The correct answer to this question is option B, that is, Duguid was a jurist who said that only right which man can possess is always to do with his duty. The last question for the evening or for the day is, which of the following is the most appropriate statement? The statements are A. Possession is a matter of law and ownership is a matter of fact. B. Possession is a matter of fact and ownership is a matter of law. C. Both possession and ownership are matter of fact only. Or D. Both possession and ownership are matter of law only. The correct answer to this question is option B, that is, possession is a matter of fact and ownership is a matter of law, is the most appropriate and the correct statement as far as the question of fact and the question of law is concerned. Thank you for hearing the session and the presentation with such a concentration, and I hope that you learned something from this presentation. Thank you.